of this intellectual discourse scenarios requiring expeditious application of the doctrine of necessity occurs for the lawmakers to now start engaging in prolonged deliberations and debates. The entire nation may be locked to an abrupt state, or even lead to the destruction of the political structure of such country. Hence the need to cling to the doctrine of necessity at some crucial stage in every existence. The bureaucratic laws for countries that practice democratic constitutionalism for such nation, because of the turn in the tide of strict constitutional amendment embedded in constitutionalism at emergency period. The doctrine of necessity then cushioned the hardship and difficulties in equilibrium amendments. In another token, the doctrine of necessity also played a key role in enhancing constitutional consolidation, thereby saving the constitution from dying natural death at some critical stage if applied in good faith. What I mean is that political leaders often apply the doctrine of necessity to score cheap political goals and ambition, hence apply the doctrine mala fide in bad faith, that is in bad faith. Cases where they have applied the doctrine of necessity to intimidate opponents and suggest rule of unimaginable repressions abound. This inordinate and flagrant abuse of rule of law under the pretense of applying the doctrine of necessity arose in Pakistan in 1954, where Ghulam Mohammed, the then Governor General, allowed himself to be lured by indiscretion, applying the doctrine of necessity to oppress his opponents by unlawfully removing members of Constituent Assembly and replacing them with Council of Ministers. The President of the Constituent Assembly, Maulvi Tamizuddin, appealed to the Chief Court of Sindh at Karachi to restrain the new Council of Ministers from implementing the resolution and to determine the validity of Council of Ministers from implementing the resolution and to determine the validity of the appointment of the council under section 223, subsection A of the Constitution. The Chief Court of Sindh allowed the suit and declared the resolution of Ghulam Mohammed on removal and replacement of Council of Ministers of the Constituent Assembly as unlawful. Consequent upon Chief Court decision, Ghulam Mohammed appealed to the Apex Court, and the Chief Justice of Pakistan, Muhammad Munir, allowed the appeal, basing the decision on the legality of enforcing the doctrine of necessity under emergency powers. The Chief Justice of Pakistan allowed the appeal and glassed the trial court for declaring the removal and replacement of the Constituent Assembly by Ghulam Mohammed. Professor Benwagweze and academic Tomahawk constantly analyzed the concept of the doctrine of necessity in his work, Constitutionality of Emergent States, as emergency powers are guided by the rule of necessity and its legality cannot be questioned. This now tells us the chronicle of the concept of the doctrine of necessity and application of emergency powers interchangeably with the doctrine of necessity in Nigeria and the gross violation of Nigeria's constitution in the enforcement of emergency powers in Nigeria. The maxim on which the doctrine of necessity is based is originated from the writings of medieval jurists Henry Braxton. Later in 1954, like I earlier said, Mama applied the doctrine of necessity by validating the extra-constitutional use of practice maxim of emergency powers by Governor General Ghulam Mohammed of Pakistan, where he cited that which is otherwise not lawful was made lawful by necessity. Consequently, affording the concept of doctrine of necessity distinctive recognition globally. The doctrine of necessity has since been applied in appreciable numbers of Commonwealth countries like Grenada, like Nigeria, Pakistan, but to mention a few. In 1985, the Chief Justice of the High Court of Grenada invoked the doctrine of necessity to validate the legal existence of a court not constituted by any of the extant laws in Grenada. The court tried certain persons for the charge of murder for executing coup against Maurice Shaw, a former leader in Grenada. This court in question was set up after the Grenada Constitution had been overthrown under a non-constitutional people's law. The High Court, who was sitting in appellate capacity, considered, without mincing words, that the lower court had come into existence in a non-constitutional manner. But the doctrine of necessity has validated based on the wide acceptability of the doctrine of necessity, and the trial was upheld, and the unlawful decision was deemed proper, so to speak. Another historic remark of the doctrine of necessity in Nigeria occurred around 9th of February 2010, although it never passed through legal firewalls in any court of law. But the then sitting president of the Republic of Nigeria, Umaru Musa Yar'Adua, left Nigeria for Saudi Arabia for treatment for 78 days. The then vice president was Dr. Goodluck Jonathan. This protracted illness prevented Yar'Adua from discharging his statutory and lawful functions physically because his state of health had deteriorated to the extent that he could only survive with the aid of life support machine. Meanwhile, the provision of Section 145 of the Constitution of Nigeria, as amended, provides that the vice president can only perform functions of the acting president once the president goes on vacation, pending the return and arrival of the substantive president. Conversely, Umaru Musa Yar'Adua died while his tenure was still running. Nigeria was thrown into a state of statutory and constitutional confusion because there's no provision in the Nigerian Constitution that stipulates the next line of action, as at that time when the sitting president dies of sick. Alas, the Senate President David Mark declared that the National Assembly was guided by the doctrine of necessity in arriving at their decision in confirming Jonathan as the substantive president upon the break of the news of Yar'Adua's death, minding the apparent lacuna in the Nigerian constitution to that effect. The doctrine of necessity can at best be described as a Siamese twins with the declaration of state of emergency and its concept, because at both instances of its execution, the constitution is usually in abeyance. That's why the clear provisions of the procedure of declaration of state of emergency in Nigeria. Still, the procedure had not followed, thereby legitimizing the erroneous procedure which executive sledgehammer having been unchallenged. I find the generator as commendable tool, capable of being used to restore peace and good order in urgent times of need, if not currently applied or immotivated. For instance, plenty state declaration of state of emergency by General Olusegun Obasanjo during the civilian rule was greeted with myriad of constitutional violations and crass disregard for rule of law and sanctity. And the sanctity of the Nigerian constitution, yet General Olusegun Obasanjo maintained clearly that Jayeola and Sheda crisis, which was the basis for the declaration of state of emergency in Plateau State, is capable of disturbing the peace, order, and good government of Plateau State and Nigeria as a whole. This position, by my understanding, insults intelligence of the dullest person in the world on how a duel between two communities would affect a whole state and Nigeria as a whole. Even the Public Order Act empowers the governor of the state to address this kind of pocket of conflict. Instead, General Olusegun Obasanjo played the ostrich and interloped into the affairs of Plateau State, perhaps because of the political differences between General Olusegun Obasanjo and Joshua Dare, the then Plateau State governor. Whereby Obasanjo's declaration of state of emergency, he suspended the governor of the state and other democratically elected officers, including but not limited to the plateau status of assembly members. Despite that our constitution only recognizes impeachment of governors of states when the time is due for such impeachment, and obviously not in times of declaration of state of emergency. There is nowhere in the constitution that the president is empowered to suspend any elected office holder like him, or even issue any declaration of state of emergency without first seeking and obtaining the prior approval of the two arms of the National Assembly. This was not done by the president before the declaration of the state of emergency in Plateau. There is equally no law that empowers the president to suspend all democratically elected institutions in the exercise of declaration of state of emergency in Nigeria. I perceive this conduct to be executive recklessness and a damnable heresy that is capable of undermining the existence and social institution of any democratic state. This brings us to the role of the judiciary in the dispensation of justice in ascertaining the concept of doctrine of necessity. So far, is it a blessing or a curse? Truly, judges command awe and petrifaction from other mortals, especially during judicial proceedings, like majestic swans, they effortlessly glide over waters of decision making. And we mortals watching from the beach, but fail to see how furiously their feet paddle below the surface. A judge's claim to power is multifaceted for the nature of his office, as he sits on the bench observing by forensic process of the exposure of frailties of litigants, pleaders, witnesses, and malefactors. While the oath intends to reinforce a sense of being placed above and superior to the struggle as an umpire, it desires the destiny, lives of a people, the nation, and happiness of persons by a stance. Most disturbing is when a judge corruptly allows himself to be controlled by political affidavits, especially in times of ascertaining the propriety of declaration of an extra constitutional policy, whether it passes for an exceptional circumstance, where such policy could be said to be proper so as to qualify to pass for the doctrine of necessity and to be so declared in that capacity. These enormous powers readily confers on judges, require them to diligently adopt and deliver judgments by deeply scrutinizing all the evidence before applying the laws to them in a more precise, coordinated, well-reasoned, articulated, and elaborately detailed, so that the judgment can be understood, void of favoritism, nepotism, or any kind of socio-political affiliation, which can be easily paraphrased by a non-initiate, a non-legal practitioner, particularly litigants themselves, without having to battle with legalese. Legalese means legal jargon fraught in judicial decisions or in a piece of legal works. The politics in the appointment of justices itself is also an albatross, which still is difficult to be surmounted, going by the provisions of Section 231 of the Constitution of the Federal Republic of Nigeria as amended. It reads as follows: the appointment of a person to the office of the Chief Justice of Nigeria shall be made by the President of the Federal Republic of Nigeria on the recommendation of the National Judicial Council and the confirmation of such appointment by the Senate. The provisions of this Constitution is self-explanatory and unambiguous, accounting for the inseparable political umbilical cord between the judiciary and the executive, particularly on the appointment of justices. For instance, here is the appointment of the Chief Justice of Nigeria. For the law here says must be done by the president, and an aphorism has this to say, that he who pays the piper dictates the tune. There is no way political influence can be separated from the appointment of justices. With this, what is the fate of a nation like Nigeria? Whenever the president feels like applying the doctrine of necessity under the pretense and style of emergency situations. This warbled process of appointment of justices in itself has subjected Nigeria justice system to the patronage of corrupt politicians with a view to securing appointments and better opportunities at the bench. Where does the hope of the common man now lies? Is this present state of things not antithetical with the maxim, the court is the last hope of the common man? No wonder there are lots of compromised judgments in election matters in Nigerian election tribunals. Here I come to the conclusion and recommendations of the topic of the doctrine of necessity, the concept of the doctrine of necessity in Nigeria and the world at large. For there to be just and fair application of the doctrine of necessity and emergency powers, the power players should not arbitrarily administer them to satisfy their selfish interest, void of public interest and welfare, because the main reason for the application of the due is to secure and protect the public policy and interests of the people. It is on this footage I submit my following recommendations in the application and enforcement of the doctrine of necessity and application of emergency powers in Nigeria. First, the procedure for the appointment of justices should exclude political intervention. Before this can be achieved, the National Assembly should commence move to amend the Constitution to correct the appointment of justices, particularly the Chief Justice of States, the Chief Judges of States, and the Chief Justice of Nigeria by the executive. The minimum academic qualification for National Assembly members should be first degree, as this will assist the Assembly to be able to think and brainstorm at almost the same pace, and the allowances of members should be drastically reduced so that the fortunes and Ghana must go policy expected in the office by potential members will be annihilated. Then only dedicated persons to service will want to vie for those offices. Seasoned lawyers and professors of laws should also be invited to the National Assembly to give legal opinions on any statutory steps the National Assembly members are about to take before debates are done. This to a considerable extent will guide members. For instance, during the civil rule of President Olusegun Obasanjo, when he unlawfully declared the state of emergency in Plateau, history added that 261 House of Representative members against 30 voted in favor of the unlawful declaration of state of emergency by the then President Olusegun Obasanjo. For the Senate, 90 senators against 5 of the senators retrospectively approved the state of emergency declared by Olusegun Obasanjo despite the gross violation of the Constitution embedded in the declaration. The most shameful thing was that Obasanjo ought to seek and obtain the approval of the National Assembly before the declaration, yet declared first before retrospectively seeking the approval of an unlawful act, which they did as rubber stamp National Assembly. What is more debilitating and abysmally pitiable, when those that Nigerians voted for, charged with the responsibility of representing the interests of Nigeria by the oaths they took before being sworn in, decided to sell out Nigerians for a pound of flesh. It is my earnest prayers that the good Lord will help us out of this quandary. The provisions of Section 215 of Section 5 of the 1999 Constitution of Nigeria should be amended for prescribing courts from inquiring or adjudicating on matters on public safety and related to emergency powers and doctrine of necessity sort of, which the President gives directives to the Inspector General of Police in securing public safety and order. And this will lead to arbitrary abuse of power. As we all know, that where there are questions that courts cannot adjudicate upon, then the life and existence of the rule of law automatically becomes threatened. Hence, I recommend the removal of Section 215 totally from the 1999 Constitution as amended because of its anti-democratic coloration. At this juncture, I beg to draw the curtain, and I hope that all these recommendations that have been made will be highly appreciated by successive governments by the grace of God. God bless Global Reference Point and Associates. God bless Ondo State, and God bless Nigeria. I'm very grateful. Thanks for the time and attention.